Lordship.
If it is necessary, we'll see.
Yes, Lordship, very much. The respondent number 8, Lordship, is demolishing. There are 3 numbers of RCC building. From 10th of May, they are demolishing in spite of having the injunction order from the trial court.
You first produce some photographs.
Yes, photographs we have annexed, and today also on 18th also the photographs were taken after filing the present rate lawsuit.
Very well, we'll take it up as and when matter is called up. Yes. Yes, any mentions?
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 5. Consent has been taken from the respondent side, Lordship. Learned Senior Counsel, Mr. S.C. Sharma is on the turnover
Request
bench.
of counsel for
I am for the respondent side, Lordship.
any
Respondent,
objections?
no objection, but Lordship, matter will come up next week, Lordship.
Lordship, on 28/5/2024.
If you have no objection, then
Actually, Lordship, they have stay, Lordship.
they have a stay, so you are agreeing to a
Regarding,
matter which is fixed.
Regarding-
You mentioned it by order. Who mentioned it?
we have mentioned,
Then why have you agreed?
but they have request us, Lordship. That's why we allow.
So another date you mention and you get the matter listed. We are adjourning it for how much time you want?
1 week, Lordship.
1 week. All right. Matter be adjourned for 1 week at the request of learned counsel for the petitioner, Mr.
MM Zaman, Lord.
M.M. Jawan, APS for the respondents.
May I please, Lordship, should bring for listing of pending writ petition for admission, Lord,
What is the subject matter?
regarding to demarcation of land, Lordship, land matter.
Pending matter.
Next week, any date is possible, Lordship.
29.
Much of Lordship.
Please, Your Lordship, I beg to mention for listing of WPC 508/2020 on Friday or Monday, Lordship.
What is the subject matter?
It's relating to construction of a drain in residential area in Golpola town.
All right. 27. 27.
Obliged, Lordship.
Lordship, item number 1 to 4, Lordship, I have taken the consent. Due to some personal difficulty, I couldn't prepare. Lordship, may take it up next week, 30 or 31st, Lordship.
30th. 30th.
Lordship, there's an interim order. There's an interim order here.
There is a
Interim order, Your Lordship.
interim order. The learned counsel for the respondent seeks accommodation for the day on personal difficulties. There is not objected to by the learned counsel. And the agenda as agreed to be listed on 30. Or let us have it on 4th of June. 4th of
Lordship,
June.
Lordship, can it be on 31st? Lordship?
Not 31st is a miscellaneous day. This appears to be admission hearing matter. Fourth is not a convenient date. We'll have it on 6th. 6th
No,
of June.
4th, okay, Lordship.
No, 4th not convenient. Let us have it on 6th. 6th of June. Matter be listed on 6th of June as agreed to by the learned counsel. Yes.
Then,
6th.
Hello.
May I please, Lordship? Lordship, in the present writ petition, there are 6 numbers of the petitioners who are the owners of the land, Your Honor, which was purchased by their predecessors' interest in 1970-78. And they had constructed 3 numbers of RCC building, Lordship, and let out to the tenants, Lordship. The 3 numbers of buildings, Lordship, consisting of 48 numbers of the commercial rooms, as it is situated in Baltala on facing NH 37, Lordship. So from the date of purchase, that is 1977-78, I have annexed, Lordship, all the sale dates of the title deeds, Lordship, that your Lordship will find from page 39 onwards, Lordship. All the sale deeds have been filed, Lordship. Mutation was granted in the Mutations were granted, Lordship. Page 39 to 151 are the sale deeds, Lordship, which shows that the land was purchased, Lordship, by the predecessor interest of the plaintiff and some of the existing plaintiffs, Lordship. Their names were duly mutated, Lordship, over the patra, respective patra, Lord. Then, Your Lordship, the respondent number 8, so Mr. Tumu, he is the son of one Dhaneshwar Garo. Dhaneshwar Garo, after selling his all land, Lordship, from the pata number 82, dag number 440, Lordship, he sold one katha of land to one Motilal Kothari, predecessor interest of the petitioner. That sale deed, Your Lordship will find at page 70, Lordship.
Hmm. Yes.
Lordship, this is the sale deed, Lordship, which was executed by Dhaneshwar Garo, Your Honor. Here the serial is Dhaneshwar Gaon. Nowadays he is writing Garo. So, Lordship, this plot of land, Your Lordship, will come to schedule of this deed, page 75, Lord.
Hmm.
Dag number, pata number is given, Lordship, pata number 82, dag number 440. Your Lordship will see on the northern side, NS 37 has been given. It is typographical mistake, it ought to be 37. So no land was left in the name of Dhaneshwar Gaonbura or Garo Lordship after selling this one katha of land. And the name of Motilal, his purchaser is the Motilal Kothari. His name was duly mutated, Lordship. Your Lordship may come to page 77, annexure 6.
Hmm.
Your Lordship will see that the names of, I have annexed all the Jamabandi of all the pattas, Lordship, which shows that the names of the purchasers, Your Honor, Kothari family, were duly mutated. I have also annexed from page 83 onwards, Lordship, the Jamabandi certified copy of the Jamabandi, Lordship, and up to page, Lordship, 96 are the Jamabandi, Your Honor, showing the names of the petitioners or their predecessor duly mutated over the plots of land, Lordship. Then, Lordship, as the aforesaid buildings over the land were constructed in the year 1983, all the three numbers of building were duly assessed by the GMC, and since 83, the tenants were occupying the land, Lordship, as described in the schedules B, C, and D, Lordship. All of a sudden, the respondent number 8, Lordship, on 22nd of 12/23, come to the suit land along with 250 antisocial elements with dumpers, 2 numbers of JCB, Lordship, and with all breaking material, and forcibly occupied the land. And thereafter, Lordship, having no option, the petitioner has plaintiff filed title suit number 95 of 24, Lordship, along with an injunction petition. And the learned trial court, after hearing 3 days, Lordship, on the injunction petition, granted injunction in favor of the petitioner, restraining the present defendant respondent number 8 from changing the nature, character, and for doing any further construction over the land. That injunction order, Your Lordship, will find at page 86, Lord. 286. Lordship, this is the injunction order dated 27 to 24, Lordship, passed by the learned civil judge Kamrup Guwahati, Lordship. I would like to place the entire fact after discussing the entire fact. This is a very long judgment. So the learned operative portion is lordship at page lordship 306. 306 last part. In the light of the aforesaid circumstances, this court perceives a pressing urgency in resolving the dispute expeditiously. Such urgency is too compelling that it warrants the omission of the customary notice required prior to the granting of the ad interim injunction in favor of the petitioner. It is the solemn duty of this court to uphold justice, protect the rights of the aggrieved, and maintain the sanctity of the legal system. Therefore, in the interest of fairness and equity, the granting of the ad interim injunction is deemed appropriate and necessary to safeguard the petitioner's right during the pendency of the proceeding. In the result, an order of ad interim injunction is granted, restraining the OP number 27, who is the respondent number 8 here. So, Mr. Tumu, his servants, employees, workmen, agents, and associates from changing the nature and character, encumbering by way of sale, lease, gift, mortgage, and from creating any liability, interest, or any manner over the Schedule B, C, D by claiming it to be Schedule E. The order of administration shall remain operative till the appearance of the OPs before the court. So this is the injunction order, Lordship. And accordingly, Lordship, the defendants appeared in the suit. Defendant present respondent number 8, who is the defendant number 27 in the suit, on first date fixed, that is on your Lordship, 14/3/24, and prayed for time for filing WSN objection against the injunction petition, which was allowed. Then, Lordship, as the interim order was enforced only till 14/3/24, then subsequently by order dated Lordship 14/3/24, page 309, the ad interim injunction was extended by the learned trial court. Trial court, Lordship, until 6/5/25. And on 6/5/25 also, the respondent number 8, Mr. Tumu, appeared and again prayed for filing WSN objection, Lordship, which was allowed. But Lordship, not only that, the building is under constant demolition. The respondent number 8, here, your Lordship, and defendant number 27 in the suit, threatened, even Lordship approached the learned trial court for favoring, and on being agreed, the learned trial court transferred the case record to the court of the Honorable District Judge. That your Lordship will find in the order dated page 312, Annexion 19, 6/5/24, Lordship. Page 312, Lordship, I am reading.
Yeah.
Para 3, Lordship. Heard and perused, considering all the aspects of the petitions are allowed, seen the letter number so and so issued by the circle officer, dispute remedy circle, that is defendant number 7, prayed adjournment for furnishing report containing that he is presently detailed in election duty. Heard and perused, considering the grounds shown there is allowed. SR of summons issued upon defendant number so and so returned after due service. Defendant number 15, 90, 25, 26 are absent without a step. Let proceed ex parte against them. Due to unusual circumstances, the court not inclined to proceed with the said suit further. Let the matter be forwarded to the Honorable District Judge Kamrupem for doing the need. Thereafter, Lordship, the record was sent to the office of the learned trial court for dispatching the record to the Honorable District Judge. Till date, the record has not been transmitted. The respondent number 8 managed in the office also, Lordship. Till date, the record has not gone to the Court of the Learned District Judge, Kamrup Metro, Lordship. And Lordship, when the buildings were demolition operation is going on, I try to file an injunction disobedience petition under Order 39, Rule 32A for the disobedience of the objection, and try to file before the Learned Trial Court. The Learned Trial Court did not accept it on the ground that I have transferred the case to the Honorable District Judge and extended the identity injunction order, stating that the petitioner should approach the Honorable District Judge, and till then, the injunction order will remain invalid. That 313. That order your lordship will find at page 313.
On 6/5 when was the last extension of the injunction order?
6/5 lordship, it was extended. Page
Where-
that your lordship will find at page 313.
Where is it mentioned?
Lordship,
Where is it?
yes, it is mentioned. Last para lordship, page 313. Since the petition number filed by the petitioner prayed to extend the interim injunction order dated 27/2/24. Hard and fast, considering all the aspects where it is allowed till the appearance of the petitioner before the Honorable District Judge. So lordship, I cannot approach the Learned Trial Court for stopping the illegal demolition going on unabated from 10th of May. I cannot approach the Honorable District Judge as because the record has been not received by the Honorable District Judge, Lordship. Till date, it is lying in the office of the trial court, Lordship. And Lordship, I filed series of, in the suit, your Lordship, the DGP Assam, this Commissioner City, Lordship, other police officers, as well as the OC Basista PS, they are the defendants, Lordship. This demolition order is going on, Lordship, with the active collusion and connivance of the higher police officers, because this land, particular land, one powerful politician wants to purchase it, Lordship. And series of FIRs were filed, Lordship, but no action was taken. Your Lordship may come to page 314, Lordship, Annexure 21. 314. This is the FIR, Lordship, dated 11/5/24 to the OC Basista PS, alleging that the demolition is going on violating the injunction. He refused to accept the FIR. Then, Lordship, having no option, the petitioners lodged through online, that is the e-complaint, Lordship, that your Lordship will find at page 317 and 22. Page 317.
Hmm.
This is the Assam Police Online Citizen Center, Lordship, and this was lodged on online containing the same FIR, Lordship, which was already I had placed dated 1/5/24, Lord. Then, Lordship, may come to, and after receiving this online FIR, Lordship, till date no action has been taken. How the higher police officers, Lordship, cooperating the respondent number 8 in demolishing the building, Lordship, by violated the injunction order. Then your Lordship may come to page 321. This is the application which I attempted to file under Order 39, Rule 2A for the causing disobedience of the injunction order. But the Learned Trial Court refused to accept it on the ground that already he has transferred the case to the Honorable District Judge. Then, Lordship, may come to page Lordship 331. 31, this is the photograph on the building. Just after the wall, your Lordship, the workers of the, it is not so clear, demolition, started the demolition, Lordship. Then, Lordship, may come to next page, 332, photographs. Already shutters of the commercial room started to remove, Lordship. So left side photo shows that this shutter was already removed, and it is right side partially removed. Then, Lordship, May come to page 334, annexure 26, Lordship. This is the photograph, Lordship. Hmm?
Yes.
Front portion of the building, Lordship, all shutters have been removed from the 48 numbers of the commercial shop of the 3 numbers of the RCC building, Lordship. And then, Lordship,
So what is your prayer in the writ petition?
my prayer, Lordship, due to enacts against the police officials, Lordship, especially the DGP, the city commissioner, Lordship, and the OC Vasishta PS, who is actively helping, Lordship. I have stated in the environment made in the petition as well in the civil suit, Lordship, that due to political pressure of a powerful political leader, Lordship, this demolition is going on unabated from 10th of May till date. Till today also they have one middle building, RCC building already demolished till date, Lordship. And the recent, on 18th, we have taken the photograph of the, because it was filed on 17th, so these photographs of 18th could not be any.
Where is your FIR?
FIR, Lordship. Three one four, Lord. Three one. Three one four. Three one. Annexure 21. Annexure 21, Lord. Page 314. This is dated 11/5. I have the honor to inform you that I, along with my brothers, are the owners of the plots of land measuring so and so, covered by patta number so and so, dag number so and so. Beltola, situated on 3 numbers of RCC commercial building in the name and style of Kothari Supermarket. The property is situated on the National Highway 37 near Health City Hospital, Khanapara. That on 22/12/20, the circle officer, Dispute Revenue Circle,
Okay,
the
let
Lost
us,
Mandal.
let us ask the respondent, yes, respondent, who's appearing?
Pardon, Lordship.
We have heard you. Let us hear the respondent.
Now, one point only I would like to clear. Lordship, there were 25 numbers of tenants in the 3 numbers of the RCC building. All they have been evicted, Lordship, and all their business materials were stock on the national highway, and those materials were put on fire, Lordship. Those things are stated. Then, Lordship, the tenant had filed a writ petition before this honorable court against their illegal eviction, Lordship, by the respondent number 8 in active collusion with the police officers, that, and this honorable court entertained that application. Notice has been already issued. That order, your Lordship will find page 175, annexure 40. Page 175, 14, Lordship. These are, there are 5 numbers of the petitioners, Lordship, in this present writ petition, Lordship, and they are all the tenants of the present petitioners, Lordship. And your Lordship may come to page 177. Filed order dated 8/1/24, this honorable court passed an order. I would like to place only the in that case, Lordship, your Lordship may come to page 180. In the middle, Lordship, para 7, issue notice returnable on 22/1/24. So already the matter has been entertained by this honorable court against the illegal eviction of the tenant by the respondent.
Yes, respondent, anyone?
Lordship.
As regard the election after filing of the FIR, that at least he has already filed an E complaint. But for that matter, what action has been taken, I can come up with an instruction. But as regard the demolition that has been taken place, so at the moment I won't be able to submit. What is the reason why, in spite of having the injunction, they have
That's
gone
right.
ahead?
So that's what the police is supposed to look into
Act
and
into it.
ensure that
Yes.
protection is granted
Yes,
in terms of the order passed by the
civil court.
Lordship, till next date, Lordship, the police commissioner, city Lordship, and the DGP may be directed to enforce the injunction order dated 27th of February 24, strictly
else-
Lordship, and stop the demolition ongoing. Today also,
Or-
Lordship, one building has been completely demolished, middle building.
let him first get the instruction.
Let,
Yes.
let a short date be fixed. I will have it because it is from Tamil.
Heard Mr. S.P. Roy. Commissioner. Also heard Mr. Siddhartha hearing for
1, 3, 4, 5, 6, 7.
1, 3, 4, 5, 6, 7. And MS Todolo for 2.
I'll furnish.
Two copies.
Whatever 2, 3
Yes, sir, I'll furnish it.
this writ petition is filed by the petitioner praying for direction. Stop the demolition. To prohibit the respondent number 8 and his associates from demolishing 3 numbers of RCC petitioner described in schedules B, C, and D by enforcing the injunction order dated 27/2/2024 passed in Miss J case number 175 of 2024 arising out of title suit number 95 of 2024 passed by the Court of Civil Judge Seniority number 1 Government Court. Stop. The counsel for the petitioner submits that the land covered by what is the tag number?
Which are describing schedule B, C, and D, Lordship. The present petition of
Page number
page number, Lordship.
68.
It is 90. Yes, Lordship. It starts from page 33.
Schedule is at 68.
Lordship.
Schedule is at 68. Is it page 68?
Of the petition 38, Lordship.
38.
Sorry, 33. And
30?
33.
33.
Schedule B, C, and D. Next page.
Covered by covered by the land described in schedule B, C, and D. Extract the part.
Land and building.
Land and building. Page number 33. Stop. The petitioners had approached the Court of Civil Judge Senior Division number 1
I am having the video, the Lordship. I have come with that pen drive.
seeking a direction, seeking an injunction, permanent injunction against the forceful demolition undertaken by respondent number 8 and his associates of the Court of the Civil Judge by judgment and order by an order dated 27/2/2024 passed an injunction order had interim injunction order restraining the opposite party number 27, its servants, employees, workmen, agents, associates, etc. within bracket, who is respondent number 8 in the present petition, from changing the nature, character, encumbering by way of sale, lease, gift and mortgage, and from creating any liability interest in any manner over schedule B, C, and D, over the land schedule B, C, and D, over the properties described in schedule B, C, and D, by claiming it to be schedule E premises. So this interim order subsequently came to be extended. So thereafter, the matter stood transferred by the concerned
Civil
court,
judge, senior division number.
civil judge senior division 1, 2, the district judge of Metro, as the court was not inclined to proceed in the suit further for unavoidable circumstances. So this order was passed on 6/5/2024. Learned counsel for the petitioner submitted till date. The case records have not been transmitted to the before the court of district judge Kampur Metro for passing necessary orders. Consequently, application alleging willful disobedience of the injunction order could not be filed. Uh, uh, Filed by the petitioner. You have filed the applications for disobedience of
Yes,
injunction?
yes, Lordship.
You have filed?
Yes. Yeah, no, I attempted to file. The learned civil judge trial court did not accept on the ground that already he has transferred the.
Submitted that when
Okay.
the petitioner attempted to file the disobedience of the ad interim order before the competent court,
कितना page में?
is informed that the matter has already been
Order
transferred.
39 to
The
2.
learned court declined to accept the application. So it is submitted that taking advantage of the situation, the respondent number 8 and his associates deliberately and willfully violated the ad interim injunction order and have continued to demolish the building and are still continuing to do so. So it is also submitted that the petitioners have been threatened with dire consequences by the respondent number 8. The petitioner has also approached this court by filing an FIR. Where is your FIR?
FIR Lordship. 11/5 Lordship. 314.
Has filed an FIR 314
Yes, Lord.
before the officer in charge of Eastern Police Station on 11/5/2024, giving full particulars of the apprehension and the illegal action undertaken by respondent rates in the state. It is submitted by the learned counsel that notwithstanding the FIR having been filed on 11/5/2024 with a request to the police authorities to enforce the interim injunction order and to prevent the respondent number 8 and his associates from undertaking the illegal demolition. No action has been taken by the
Proceed the fees to accept. Then we file online.
stop. It is submitted that this FIR was not accepted by the Bohisto police station and consequently the petitioner had to take recourse to file the online FIR.
Online FIR page 317.
Stop. The e-complaint, a copy of the particulars of the e-complaint filed by the petitioner is enclosed to the present petition that is pending. Stop. Notwithstanding the e-complaint being filed, no steps have been taken by the respondents, more particularly the concerned police station, the commissioner of police as well as the SP concerned, restraining the respondent number 8 and his associates from illegally demolishing building in spite of order of ad interim injunction order passed by the court. Council for the petitioner submits that the respondent number 8 and his associates are acting at the behest of powerful politicians. And therefore, the police authorities are refusing to interfere. So Being faced with such a situation, the present writ petition has been filed with the petitioner, praying for it. Having heard, there is one more right. The learned counsel of the petitioner has also submitted before the court that the tenants who were carrying on their trade and business in the commercial buildings belonging to the writ petitioner, having been forced out of their premises and their articles and items being demolished or destroyed by the respondent number 8, had also approached this court by filing WPC number 21 of 2024 of this court had issued notice on 8/1/2024. Matter is still pending before the court. Mr. A. Sharma, learned counsel for the respondents
Yes, for 1 and 3 to 7.
1 and 3 to 7. Government advocate, you're the government advocate.
Yes.
Government advocate appears on behalf of respondent 1 and 3 to 7. So, MSN employed, learned standing counsel appears on behalf of respondent number 2. Since the counsel has already entered appearances, extra copies will be furnished within 2 working days. You furnish extra copies
Sure.
within 2 working days.
I'll furnish, how many copy you need?
Notice steps on respondent 8 by registered post 80 as well as usual courts. Trustee is also permitted. To be routed to the office. The returnable 2 weeks. Now, respondent authorities, namely the
DGP Assam Lordship and the city
6,
city
particularly
commissioner.
6 and 7. 6 and 7 are directed to place before the court a status report in respect of the FIR lodged by the petitioner through the e-portal, and also to ensure that the order passed by the Court of Civil Justice Senior Division number 1 Kapruk Metro entitled in Ms. J case number so and so arising out of so and so by order dated so and so is adequately enforced, and to ensure that the order is not violated without leave of the court.
Demolition may be,
The the respondents 6 and 7 till the next returnable date will ensure that no further demolition of the buildings in the land described in Schedule B, C, and D is carried out without leave of this court. Matter be listed again. Tell us when you can get it. 2 weeks. We've given you 2 weeks.
2 weeks Lordship.
14th of June.
Obliged.
May I produce? Here now I am appearing for response 225, madam. And I need further time, madam, to file affidavit, madam.
Who is respondent 5?
225, madam, for BPCL, madam. Matter relating to my termination of dealership.
Examination of a dealership of petroleum.
You want to file an affidavit?
Yes, madam.
You have not filed an affidavit.
No.
They file affidavit in response to MLA interim order passed by the Honorable, but not in the main.
How much time do you require?
3 weeks, madam.
3 weeks.
I only pray for a fixation of a date, my lord, because
Yes.
I am now
Yes.
out of
Mr. S. Botagur, learned counsel, hearing for the respondent. 2, 3, 4,
5 minutes.
5.
One is a formal part.
Raised for 3 weeks time to file the affidavit. Mr. B.J. Ghosh, learned counsel, will not obtain but submits that the matter be listed on fixed date. Matter be listed again on 21st June.
Hello, this matter pertains to non-payment of contractual bill, Lordship. The petitioner executed a work, Lordship. It was the construction of a road, Lordship. The value of the work was 30 lakhs, Lordship. He has executed.
Where is the admission?
Yes. That is the bill prepared
Right here. Yes,
from annexure 5 onwards, Lordship. An inspection report, page 20.
page 20.
Yes. Page 20 and 25 may be seen. Page 25 is the bill which they have prepared, Lordship. Pro forma bill prepared by the department.
Yes.
Page 25.
Yes, respondent.
Well, this could perhaps be disposed of, my lord, in terms of Surrogacy.
You verify and pay. You verify the claims and pay.
In terms of Surrogacy judgment, my lord.
Right,
Yeah.
comes early, but then can be an endless wait.
There has been a long list of,
So the name of the contract is at page 20, is it? Name of the scheme.
Page 25 is also there, Lordship. In page 25, Lordship.
Page 25.
The bill which they have prepared is the petition. Serial number 6.
What is the net amount payable? 24.
30 lakhs.
Huh?
30 lakhs. Now after deduction, it will come to 20. As per the bill, it is 24 lakhs 21,068.
Heard learned counsel. Returns that covered by the Samsar Ali judgment is both of page 25. Details are available. If it is Samsar Ali, we can't give you an outer limit. But we can say that the department will endeavor to clear the bills admitted dues of the petitioner after due verification in the outer limit of 4 months from the date of receipt of the paper.
An admitted amount. Right.
Yes,
Here, this is second round of litigation, Lordship. Here in this case, what happened? The petitioners got married in the year 2010. And due to some difficulties, they could not get the blessing of parenthood, Lordship. And thereafter, they initiated IVF technology, Lordship. And even then, they failed to get that blessing, Lordship. But subsequently, on 21/12/2021, they adopted the procedure of surrogacy. And on 25/12/2021, this Act, Surrogacy Regulation Act came into force. which divide lordship in lordship that provided some mechanism that the couples have to obtain the couple have to obtain lordship that written permission from the concerned authority. And because of that act lordship, they approached before this honorable court. And this honorable court by page 41, your lordship will find that earlier writ petition was disposed of. Page 41
Yes.
was disposed of on the ground that that mechanism has not started in the state of Assam. And prior to that, they had started that procedure. So they were allowed to continue with the procedure. Lordship. Page 44, your lordship will find the finding. And accordingly, lordship, that subject to fulfillment, lordship, that therefore they were fulfilling at that point of time, and
No,
therefore
no, no. Kindly read the paragraphs in page 44.
under the aforesaid facts and circumstances, this court is of the considered opinion that, in view of the fact that the state of Assam is yet to come to a stage whereby the requirements under the Act of 2021 may be granted. More so with regard to the permission, and therefore petitioners shall not have any embargo in pursuing the remedy in any other state, including the state of West Bengal, which can be considered by the respective state subject to fulfillment of the other provisions of the Act.
So what was the direction? They were permitted?
To undergo the procedure. They were undergoing the procedure in the state of West Bengal.
In any other state,
Any other.
not in Assam.
So that was not specifically said.
So
But as she was undergoing in the state of West Bengal, so it was permitted to take up. So then Lordship may kindly turn to page 45. After this order, they again started that procedure. Page 45, 46. And subsequently what happened, Lordship, that on 14th March of 23, page 47, Lordship may kindly see, one notification came into force. They said that donors' egg cannot be used by the couple. This was the bar. And this notification also subsequently substituted, and this is not in force as on today, Lord. Then your lordship may kindly see, during pendency, while this notification was in force, some persons approached the honorable apex court, that your lordship will find page 48. That notification was challenged, and they were after considering all the aspects, lordship, they were permitted to undergo the procedure as an interim relief. The point where I am raising, page 57, lordship may kindly see, last paragraph.
Yes.
So because of that notification, I was affected. Now this notification is not in the statute and not in force. So I have no difficulty in undergoing the process. The only difficulty is that because of this the 2 rounds of litigation, lordship, now I am overaged. And for that, lordship may kindly see page 59. Similarly situated person, lordship, approached Delhi High Court, lordship, they were granted the relief. Page 7, paragraph 7 and 11 to 14, lordship may kindly see, similarly in my situation. Page 7, lordship, paragraph 7, page 60. May I read? The petitioners and intending couple aging nearly 51 years find themselves precluded from commissioning a surrogacy due to the age bar introduced through the Surrogacy Regulation Act 2021, despite having initiated the process before the date of enforcement of the Act. Through this petition, they seek a declaration that section 4(3)(c)(1) of the SR Act, which imposes an age restriction in respect of intending parents, impairing on their reproductive autonomy, protected by Article 21 of the Constitution of India. So this was the issue. Lordship may now kindly turn to paragraph 11, page 62.
Hmm.
This court has carefully examined the aforesaid content. The petitioner's effort to convince, bear and deliver a child have regrettably yielded no success. Petitioner number 1, the mother has also surpassed the age criteria stipulated in the ART Act, rendering her ineligible for further IVF treatment to facilitate childbirth. Their only remaining option is gestational surrogacy. However, they now face a significant dilemma due to the contentious provision in question, section 4(3)(c)(1) of the SR Act, which reads as follows. Lordship may kindly see that the intending couple are married and between the age of 23 to 50 years in case of female, and between 26 to 55 years in case of male on the day of certification. The date of certification. The petitioners have encountered a gridlock in obtaining the eligibility certificate primarily due to their age exceeding the prescribed limit. However, it is essential to note that the petitioners commenced their IVF treatment and embryo was created on 3rd December 2021, when the age restrictions outlined in both the SR Act and ART Act were not yet in effect. Furthermore, it is essential to emphasize that the embryos were created through the fertilization of gametes that were recovered and frozen when the petitioner's ages were well below the age limit introduced under the impugned provision. Prima facie, the impugned provision cannot be applied retrospectively, thereby disqualifying individuals who had already initiated or undergone the ART process in accordance with the prevailing law. Mr. Chetan Sharma, learned additional Solicitor General, has also fairly pointed out that the legal implications of the provision should be prospective in nature. Considering this crucial fact, in our opinion, the impugned provision should not be interpreted as an obstacle to the petitioner's pursuit of surrogacy. At this juncture, we may reference a judgment passed by the High Court of Kerala in Nandini case Supra, as it bears significant relevance to the issue at hand. In that case, the court was dealing with section 21(g) of the ART Act, which prescribes the age limit for couples desirous of availing ART. It was held that if the prohibition under section 21(g) is understood to be prevailing continuance of ART services that had already commenced, it would amount to unreasonable and unjustified restriction on the reproductive choice of the commissioning couple and would militate against the liberty granted under Article 21 of the Constitution. As a result, the court determined that couples who had initiated IVF treatment prior to 25th January 2022, date on which the ART Act should not be adversely affected by the age prescription outlined in the ART Act. This precedent set by High Court of Kerala shed significant light on the prospective applicability of standing provisions and reinforces the argument in favor of the petitioner. Thus, while the court deliberates on the challenge on the validity of section 44(3)(c)(1) of the SR Act, considering the petitioner's situation and the peculiar facts and circumstances of this case, we are inclined to grant an interim relief. It is imperative to acknowledge the profound emotional and psychological distress endured by the petitioners as a consequence of their present predicament. Their inability to proceed with the surrogacy procedure has placed them in a state of anguish and uncertainty, deeply affecting their mental and emotional well-being.
What is the status of the writ petition today?
That act is challenged in the Honorable Apex Court regarding those some certain provisions, including those age and that is still pending. And Honorable Apex Court clarified, some writ petitions were filed. They were directed to file the writ petition before the concerned High Court, and liberty was granted to the petitioners. And also one observation is there that pendency of the writ petition will not be barred to consider a case of the petitioners therein as well as similarly situated persons, which I am. That I am just placing before your lordship. The first one is that writ petitions which were filed subsequent to that interim order were sent back to the respective high court. And in last portion, your lordship will find it is further observed that the pendency of the writ petition before this court would not come in the way of the jurisdictional high court in considering the writ petitions to be filed by these applicants or any other similarly placed persons in accordance with law. And regarding that notification in the second order, it is there that it is no longer in the statute now.
Now, you are not proceeding with the,
Because of that age bar
Age bar.
as on today, Lordship. Because when I filed the writ petition, notification was in force. But during pendency of this writ petition, they have withdrawn that notification. Now only problem is that
now,
age.
who is responding? Yes, help.
So far as sort of the age part is concerned, is there in the statute. That part, my lord, I would leave to the honorable court, my lord, to do. But my lord, during the first time on the petition, I approached the honorable court. This particular act was not made functional in the state of Assam because of non-constitution of the board as per section 26.
They
Now
were,
it has been constituted, members have been appointed, it is fully functional.
they were appointed, they were permitted. But you
Yes, sir.
proceeded in the state of West Bengal.
Yes, I will proceed, but only fact is that this honorable court allowed me to continue with the procedure. But subsequently that central notification came up. So I cannot proceed in that state of West Bengal because I need egg of donor lottery. That donor egg was prohibited by that notification, which is now withdrawn.
My lord,
And
otherwise,
taking
my
this entire litigation lottery, now I am over it. This is the that relaxation may be granted. I will proceed in.
so far as the prayer made in the writ petition is concerned, my lord, the petitioner has, my lord, prayed for relaxation of this notification as page 47.
Hmm.
This notification has been now withdrawn. So relief, my lord, sought for in the writ petition as he has already got because this embargo, my lord, laid down in this particular notification of 14th of March 23 is not effective as on date.
My another prayer is-
Additional prayer is now, my lord, that age should be relaxed in his part.
No, my prayer is that as to why a further direction shall not be issued restraining the respondent authority from insisting on the compliance of the provision.
I think you should respond properly.
Lordship.
Because here is a question of giving them a liberty only on the ground that you proceeded.
Yes.
Now,
That
see,
permission is already granted, only that age factor is there.
no, but if you had proceeded,
Got
you can't say you had proceeded prior to the age bar.
Got
Because of the age bar, you had stopped the process.
No, not because of the age bar.
Because of the
Here, Lordship,
Because of the earlier 47 notice.
notification.
Ah.
Because of that notification, therefore I have filed this writ petition. And during pendency of this writ petition, notification is withdrawn. Now I am over it. That is the difficulty. Because admittedly, it is due to litigation. Earlier, when my writ petition was pending, at that time I was eligible. But that board was not constituted. Authority was not.
You get your instructions, respond, Mr. Gogoi,
Lordship.
because this will have some ramification.
Yes, my lord.
This will have some ramification. Now, how do you prove that you had proceeded earlier? in terms of the Delhi High Court
Sir.
order. You are asking an order in terms of the Delhi High Court order.
Because it is admitted, because Lordship may kindly see that my first order was passed, Lordship may kindly see that page 41. This is the first order.
You are permitted.
Yes, I was permitted.
Huh.
Then your Lordship will find page 45 on 13 to 2023. Prior to that notification that I cannot use donor aid.
The process, does it require any registration or anything like that under the Act? Mr. Gogoi,
My lord.
does it require any registration for
Well,
the
that-
couples?
Yes, well, it's required.
Permission from the concerned authority is required.
Huh?
It's required. Sir.
Where is it? Where is the
Well,
purpose?
I have stated in my paragraph 4, your Lordship will
No,
find.
if a statement is all right, you show us a
So
document.
that act I have put it there. In paragraph 4.
My lord, we'll see, my lord, proceed having this
No.
act. Section 4, Roman 2A. Oh,
Roman 3.
Roman 2. 4(2)(a). When an intending couple has a medical indication necessitating gestational surrogacy, provided that a couple of Indian origin or an intending woman who intends to avail surrogacy shall obtain a certificate of recommendation from the board on an application made by the said person in such form and manner as may be prescribed.
This is a section which was brought later, or was it there?
It is there in the parent act. Sir.
It is there.
Yes. But that board, my lord, which is mentioned in this particular provision, was not constituted, was not fully functional in the state of Assam. Now it is functional. And Lordship will find, my lord, Lordship may see section 26. It is the constitution of State Assisted Reproductive Technology and Surrogacy Board.
It is admitted fact that when my first aid petition was disposed of at that point of time, that was not fully functional.
It is already mentioned in the earlier order, admitted.
Now see, come to Roman 3, Roman 3A1.
My lord. A certificate of a medical indication in favor of either report.
You require a certificate from the district medical board.
Right.
So all these papers to show that you had started the process.
Yes, that the medical documents I have enclosed here.
But medical documents don't say anything except prescribing drug
No,
and some examination.
Lordship,
There has to be a certification to
Yes, yes.
that you have initiated the process
Even from required from West Bengal.
from wherever,
Yes.
somewhere to
Yes.
show that this is the process going on.
Oh.
Because if these provisions were there prior to the age limit,
no, prior to this age limit was not there. This is only from 25/12/2021 this has come.
no, I'm talking about this section 4.
Lordship.
Section 4 was there in the Parent Act, okay? Section 4 requirement.
Yes,
It is in
section
the
4 was there, but your Lordship may kindly appreciate one thing that if one person, one couple wants to go through surrogacy procedure, they have to obtain permission from appropriate authority. And when I was undergoing that procedure, there was no appropriate authority in the state of Assam. Therefore,
No,
I
but
filed
you-
writ petition before this honorable.
You continued in the state of West Bengal.
No, they have to, Lordship, I was residing here, so I have to obtain permission from here. And thereafter, I can continue with the procedure anywhere in
How
the
can
state
you
of.
say that you had continued with the procedure? That means you did not continue with the procedure. You submitted that
Lord.
you had initiated with the procedure.
Lord.
And therefore, in terms of Delhi High Court, you want an order permitting you to go because you initiated the procedure prior to the age limit.
Lord.
The order of this of the coordinate bench shows that you had started the procedure in the state of West Bengal.
Yes.
Now, if you had started in West Bengal, there must be some authority certifying.
Yes, that documents are there, page 26 onwards, your Lordship will find.
These are prescriptions. under the provisions in terms of section 4 of the act.
No, my whole case is that this act came subsequent. Prior to that, this, even though your lordship says that these are prescriptions, this prima facie shows that I have initiated that procedure. I was undergoing that procedure. That is my whole case.
We'll examine it. Okay. Heard learned counsel. If you want to file a response, please go.
My lord, I will.
This will have to be examined. It's not an open and shut case, as you are trying to project.
Only thing is that lordship that I'm
We'll consider that, but before that, you have to satisfy that you had initiated the procedure as per the provision of law, whatever was there.
no initial after prior to this there was no act, no rule.
You proceeded prior to 2021.
Yes. That document is here. Lordship may kindly see page 28. Page 28.
Because from the prescriptions that you are showing,
Okay.
it's just a medical prescription, some examination.
Okay.
The fact that you are going for
Because
this
prior
procedure,
to that there was no requirement for
there
any,
has to be a medical opinion at least.
no that lordship will find in the page 28 in the prescription itself it is written lordship. Wants to try and serve instead of surrogate. That surrogacy was that IVF technology.
Instead of surrogate.
Yes, and in top portion your lordship will find so and so 6 surrogacy stop medicine. So all these things were there. Earlier there was no requirement for any permission. Therefore, only the consultation with doctors we could do. And because of this order, lordship, the same doctor again, lordship, started that procedure, lordship, because I was fulfilling all the requirements. Page 45 and 46.
No, we'll have
lordship,
to examine this matter, not like this. Heard learned counsel for the party. We go for health, a guy on board. Do you have anything to submit?
Act has already that age has already relaxed that my family. That is, age has been already relaxed.
How?
My lord, he silenced the notification, my lord.
47.
Yes, my lord.
So 47 is for something else.
No, not 47, my lord. Rules 50, my lord.
Page number?
Page number 23, my lord. That is
23 is the prayer.
yes, my lord. Section 50 of the my lord, of the allow the petitioner to complete the procedure for surrogacy, my lord. Section 50 of the act, my lord.
Yes. So what is relate?
Section 50 of the letter. Amendment to 50 of the letter is to a notification. Yes, my lord, page 47 is the notification, my lord. By that notification, my lord, in exercise the power conferred
No,
by the
that
section
has been
50.
relaxed.
Yes.
His prayer is now relaxation of the bar of age.
Yes, my lord.
What do you have to say on this respect?
That is the statute, man, whether he.
He is relied upon a Delhi High Court judgment.
Yes, my lord, Delhi High Court judgment. That is page number 59, my lord.
Heard so and so. Okay. Let the respondents complete their instructions and file necessary affidavit to advise. Matter be posted again on 18 June.
Lordship, may I pray for a short date, Lord?
13 June.
Currently, Lordship, on first week of June, Lordship.
First week, they will not complete their instruction.
On 7th,
On 7, let us have it on a hearing day, we'll pass orders. 13,
I may be allowed to file additional affidavit if required.
petitioner is also permitted to file additional affidavit.
Item 9 and 10 are connected with the series matter starts from item 11 logic, the TV hospital series logic.
Yes.
And
Very well. So we'll take it up with 11.
Yes, sir.
Okay.
Item number 9 and 10, my lord, both the cases.
Roll out 11. 11.
Lordship, last occasion, Lordship, we took leave of this honorable court to file further additional affidavit to bringing on record some corrigendum for the error correcting earlier, Lordship. So, yes, yesterday late evening, we have received our instruction, Lordship. So 10 days time may be given to us to file our affidavit, Lordship, in the 4 matters that has been already recorded in the last order 25. Right, for 2000.
Corrigendum.
Yes, yes.
Yes. Petitioner. What do you submit? Learned State Council, Mr.
SR Borua.
S.R. Borua submits that he has received instruction to file additional affidavit to bring on record a corrigendum correcting the errors that are earlier corrected. Stop these affidavits have to be filed with WPT. So and so, so and so, so and so. You check up the earlier order 25. By the earlier order, the petitioners were respondents were granted 2 weeks time by the affidavit. Mr. Borua renews his prayer today. For further, how much time do you require?
10 days.
2 weeks time to file additional affidavit. Let all these matters be posted after 2 weeks. A date.
Can it be a date with fixed?
Registry will fix it.
But otherwise, can it be on 4, 6 or 6, 4, 6, 6, 4th of June or 6th of June?
You don't know that. There are several matters fixed. It will now go to July.
Or can it be on 11th of June? 11.
It can be on 18th. Janu. 18th. To be called up again on 18th. Along with 9 and 10. 18 June.
Not.
But
First street.
None appears. After that hold. He pulled up again. Tomorrow. None is appeared for the petition. For the party. Be pulled up again next week. Yes.
The issue is that my juniors were getting higher pay than me in the cadre of assistant engineer. Their contention is that they produced one OM where they say that, my lord, I'll not, the stepping up of pay will not be available if I was given promotion under any special law. Lordship wanted to have my promotion order.
Yeah.
I was promoted to assistant engineer under regulation 4D and then subsequently I was regular engineer. So there was no special order for my promotion. Under normal rule, I was promoted.
Yes.
The finance department, my lord, they were relying on this circular or guideline, my lord.
Which circular?
My lord, that will be paper book page number 57.
Yes.
57, last clause, my lord, clause 3. stepping up of pay will not be available when a junior government servant promoted to a higher post prior to his senior, as per special rules, special order, he cannot claim equalization of his junior. Even my submission, this is something else, my lord. But their contention was that if I'm given promotion under a special rule or special law, then stepping up of pay may not be available. So Lordship wanted to have my promotion order, my lord. Other facts, my lord, that I am promotion senior to my lord, that your Lordship may kindly see.
What does the FR say about stepping up fundamental rule?
FR, I relied on one office memorandum that clearly supports my case. If this is the case, this is the book, my lord, page 78.
FR. 78. 22.
22, my lord.
78.
Finance establishment, a department office memorandum,
30th of June.
30th of June.
Yes.
It has been observed that the government servant whose pay on promotion to a higher post regulated under FR 22C may sometimes stand to be lower than the pay drawn by a junior official who is subsequently promoted to an identical post due to the fact that the junior government servant joined the promoted post only after getting the increment due in the lower post and thereafter joins the promoted post and fixation done under 22C. After considering all aspects of the matter, it has been decided that in case of fixation of pay under provision FR 22C on promotion to a higher post of government servant concerned, be given an option of fixation of pay for higher post as under. Either his initial pay in the higher post may be fixed on the basis of 22C straightaway without any further review or actual accrual of increment in the pay scale of the lower post, or by pay or his pay on promotion may be fixed initially in the manner as provided under 22A11 on the date of his actual promotion, which may be refixed. Certain procedure has been given. This is also regarding stepping up of pay, my lord. This exercise has not been done, my lord.
FR 22C. What is FR 22C?
Yes, my lord. Can you repeat? P.
Deleted.
Now, Lordship will find page 75, my lord. FR 22 has been deleted with effect from 1189. But my pay was required to be fixed under 22C prior to this deletion, madam. Had it been fixed at the time when my juniors were promoted to the rank of assistant engineer in 1982, I have relied upon three judgments of Supreme Court,
Hmm.
which categorically lays down the principle that a senior incumbent in a cadre in no circumstance can get lower pay than his junior. And the principle of stepping up has to be followed, madam.
Which is the judgment? 97.
Three judgments I have relied upon, madam, for the day. 97 years, 97, 3 SEC 176, paragraph 5, 6, and 7. And then 2009 3 SEC, paragraph 17, madam. And 97 11 SEC 463.
90.
1997 11 SEC 463.
Page number?
Uh,
I mean, paragraph number?
Paragraph 4, my lord.
You're relying on paragraph 4.
4. Yes. Four 66 is relevant, my lord. One para has been fixed again. Para 4, 5, and 6. 6 will be more relevant, my lord.
Take us through the judgments one by one. Para 6.
My lord, which the last one?
So all the judgments.
All the judgment, my lord. So I am relying on 97 3 SEC, my lord. Para 5, 6, and 7.
Yes.
The question for consideration therefore would be whether the respondent who had not been posted against the identified post carrying a special pay of 35 a month can claim fixation of their pay with rupees 35 per month in the cadre of senior clerk even on notional basis, whether the respondent can claim for stepping up of their pay in the promoted cadre of head clerk when their juniors who were later promoted were fixed up at a higher slab in the cadre of head clerk, taking into account the special pay which they are drawing in the lower category. Here the juniors are getting some special pay for doing some hard work. Supreme Court has said that this special pay the senior will never get, but senior will always get the benefit of stepping up of pay when a junior comes to the cadre matter. So far as the first question is concerned, it is to be seen that the special pay of 35 per month is attached to certain identified posts in the category of senior clerk, and therefore only those who would be posted against those identified posts can claim their said special pay. Respondents who had already been promoted to the higher category of head clerk cannot claim that special pay even on promotion basis merely because their juniors in the cadre of senior clerk were given that special pay on being posted against those identified posts carrying the special pay. It is an additional pay attached to the post, and only any incumbent who occupies the post can claim the same. The claim of the respondents on this score, therefore, is not sustainable. So far as the second question is concerned, it depends upon the applicability of the principle of stepping up. Admittedly, the respondents had been promoted earlier to the category of head clerks, and some of their juniors who were continuing as senior clerks against the identified post, carrying special pay of transfer per month, on being promoted to the post of head clerks later than the respondent, got their pay fixed at higher level than the respondent. Under the provisions of fundamental rules to remove the anomaly of the government servant promoted to or appointed to a higher post, either drawing a lower rate of pay in the post than another government servant junior to him in the lower grade and promoted or appointed subsequently to the higher post, the principle of stepping up of the pay is applied. In such cases, the pay of the senior officer in the higher post is required to be stepped up to a figure equal to the pay as fixed for the junior officer in that higher post. The stepping up is required to be done with effect from the date of promotion or appointment of the junior officer. So this is important, my lord. on the refixation of the pay of the senior officer by applying the principle of stepping up, the next increment of the state officer would be drawn on completion of the requisite qualifying service with effect from the date of transfer. The principle becomes applicable when the junior officer and the senior officer are belonging to the same category and post from which they have been promoted, and in the promotional cadre, the junior officer on being promoted later than the senior officer gets a higher pay. This being the principle of stepping up contained in the fundamental rule, and admittedly the respondent being senior to several other senior clerks, and respondents having been promoted earlier than
Yes.
many of their juniors who were promoted later to the post of head clerk, the
Yes,
principle
yes.
of stepping up.
Respondents, what do you have to say?
Yes, in this case, my lord, respondent was in my position, my lord. He was though junior, he was promoted earlier.
He appears to be entitled to the claim made.
My lord.
What about his claim for stepping up of pay?
The department has
Stepping up.
stepping up. It is not on the basis of the gradation, it is the depends on the pay scale, my lord. It has been cleared from our letter, my lord, that we have annexed in our affidavit, my lord. Closing, may kindly take up our affidavit, my lord. Filed by Ratul Bora, my lord.
Page.
Page 45. Running page.
Yeah.
Extra file. The letter from the Under Secretary Transport Department to the petitioner, my lord, regarding equalization of pay. I am directed to inform you that refixation of pay do not depend on seniority of gradation list, as your pay was never more than the other incumbents, that is Sri K.K. Dekar, Sri Ratan Singh, and Muhammad Samidur Rahman. Hence, there is no scope for refixation of pay with others as per your claim. This is the letter issued on 8 December 2011, and this letter was never challenged by the petitioner. Person may kindly have the fair petition, my lord. Page 13.
No, these people were your juniors, Mr. Chakraborty.
Huh?
Page 45.
Yes,
There are
Lord.
3 names.
Dekar, Ratan Singh, they were junior.
They were
They
junior
were senior to me in the feeder cadre.
feeder.
Subordinate engineer, they were senior to
Then
me.
you were promoted earlier.
Plus, may kindly have a look to the clear picture is given in their affidavit, my lord. They have included the affidavit, my lord. One comparative chart they have given, my lord.
This chart was prepared by the accountant general, my lord, in running page 43, my lord.
Yes, my lord. 43. 43, the entire detail has been given. Now, here, your lordship, find number 1 is the petitioner, and A.K. Dekar, Ratan Singh, and Samad Rahman, they were who were senior to me in the feeder cadre. Now, H.N. Thakur was appointed on 22nd of September 1969, the writ petitioner. And they were, A.K. Dekar was appointed in 63, Ratan Singh 64, and Samajur Rahman was 63. Then your lordship may come to serial number 6, promoted as assistant engineer. I was promoted on 7/4/1981. And they are promoted on 84, 82.
How were you promoted?
Yes, my lord. Because they were all diploma holders. Under the rule, my lordship goes, my lord. Rule says, my lord. I was also diploma holder, but in course of service, I obtained the degree. In the rule, it is categorically mentioned, my lord.
You joined service as what? Section is what?
As my lord, subordinate engineer, my lord.
Sub-engineer.
Subordinate engineer.
Yes, please.
My lord. Then, at this stage, my lord, my pay was to be stepped up to the pay of Ratan Singh. Ratan Singh was the first junior who was promoted to assistant engineer on 4/1/1982. A third column, my lord. And others, they were promoted later on, my lord. Lordship, kindly see the pay scale. I was getting 875, and Ratan Singh was getting 1075 as assistant engineer.
Why were you getting
Less,
875?
lesser pay because I was junior to them in the feeder cadre, my lord. I joined around 6 years, not 6 years, my lord. Around 6 years later than them. So they got increment in the feeder cadre. But in the course of time, I obtained the degree. That's why I was given promotion earlier to them, madam. In the next available vacancy, I have to be immediately given, madam. That is the rule. And these are not in controversy, my lord. These are admitted facts. When Ratan Singh was promoted on 4/1/1982, my pay was required to be stepped up to his pay. And that would have solved all problems, madam. Petition also came earlier around, my lord. It was sent back to the government to take a decision on this. Government didn't do anything, my lord, so he came for the second time. Huh?
Okay.
The lordship wants to have a look on the rule, my lord, why I was given earlier promotion. That is not in controversy, but if the lordship wants to see, my lord.
Rule number?
My lord, I'm telling. That will be page 5, my lord. Rule 11, my lord.
Yeah.
My lord, the vacancies to be filled up by promotion of sub-engineer. This is regarding assistant engineer, my lord. It shall be so fixed that the promotion of assistant engineer do not exceed 30%. Then rule 4, a member of the Assam subordinate engineer service shall be eligible for promotion as assistant engineer subject to the following conditions. He has rendered minimum 8 years of service as a subordinate engineer on the first transfer. He has successfully undergone the training transfer. Now, E, notwithstanding anything contained herein before in this rule, subject to suitability, a subordinate engineer grade 1 of the Assam subordinate engineering transfer service on his acquiring the academic qualification as prescribed for direct recruitment, direct recruit assistant engineer shall be promoted as assistant engineer in consideration with the commission as with consultation with the commission as provided in the rule 12 against the next available vacancy in the cadre. and such post shall be treated as direct recruitment to the cadre. So immediately he gets the qualification, the next available vacancy is to be promoted. That's why his promotion is not under any cloud, my lord. And as I have submitted, my lord, he was not promoted under any special law, under 4D first, and that was ignored.
The contract statement, prepared by the accountant general, page 44, running fixed.
Yes.
They have
43.
given a chart in the
44.
accountant general, 44, madam. Serial number 1, Sri A.S.N. Thakur, madam, the petitioner, and then the other respondent name were given. Pay, H.N. Thakur has received, pay received a scale of pay 670, 35, 10, 20, 40, 50, 100 per month, and pay fixed at rupees 865 per month. So you may kindly note this 865, and other respondent has received 985, 985, 985. And that's why this accountant general has informed the department that his refixation is cannot be possible because he never get the higher pay than the other respondent. We have submitted all the documents to the accountant general and the finance department. Their views is that he is not entitled because he was never senior to the other respondent in regard to the pay scale, my lord. It is not the department view, it is the view of the concerned department who calculate for refixation of his finance and accounting.
FR 22C says that
But lordship, appointment order, my lord.
no, there is no
Promotion.
dispute on that.
Yes, my lord.
He was appointed later. So by the time he was appointed, the others have put in 4, 5, 6 years of service. So they had got the increment, their things were higher. All of them were appointed on the qualification of having diplomas.
Diplomas,
He completed his degree.
degrees.
Because he completed his degree, next available vacancy, he got the opportunity. He was promoted.
Promoted.
Now, having been promoted under FR 22C, his pay has to be stepped up to the higher pay drawn by the junior in the feeder category.
So his promotion order should be taken into consideration under what circumstances he has been promoted, because there is a notification of the finance department. They have annexed in their affidavit, my lord.
Where is that?
Finance department not affidavit. is my lord.
My lord, that's clause C, my lord,
Oh, see.
clause C. Yes, that will be page 57, my lord.
Better than me for the finance. Finance.
Yes.
The prayer of the writ petitioner, the exact claim of the writ petitioner is with regard to refixation of pay by stepping up of the pay with his juniors and recalculate the pension.
Correct.
It is the pleaded case of the petitioner that he is claiming stepping up of the pay, as it appears, my lord, at page 13 of the writ petition, the prayer portion. I will draw my lord's kind attention to the affidavit, my lord, filed by the finance department. His lordship takes up the affidavit, my lord, filed by my lord, the respondent number 3. That is filed on my lord, 3rd of August 2019.
Leela Kanto.
Leela Kantobora, and so like my lord. Their lordship may kindly come to paragraph 7. Before that, lordship may, I'm sorry, my lord, lordship may kindly come to paragraph 5. Paragraph 5 of that affidavit.
Yes.
I will read it, my lord. The deponent begs to state that a proposal was received from Transport Department on 9/9/2013 regarding fixation of pay of the petitioner Sri Hemendranath Thakur with that of his juniors, Sri A.K. Deka, R. Singh and Mohammad Samjidur Rahman, file number so and so. the said proposal was examined in Finance Establishment A department. It was seen from the examination that the petitioner was junior to A.K. Deka, R. Singh, then so Rahman. As such, at Finance Establishment endorsement dated 22/2014, Transport Department was requested to examine the proposal with reference to point number 3 of Office Memorandum dated 10/9/97, and a clarification was sought as to how the petitioner was promoted before his juniors. But till date, no clarification has been received from the Transport Department. Now, the Finance Department is relying on that OM of 1997, which my lord will find that in the same affidavit at page number 6, my lord. Page number 6. Prior to that, at page number 5, lordship will find the endorsement.
1 minute.
Okay.
Page number 6.
Page number 6. Page number 6 is the OM of 1997. It is with regard to, my lord, equalization of pay on promotion, my lord. May I read it, my lord?
Yes.
Finance Department received a number of proposals for equalization of pay of senior government employee with his junior, for stepping up of pay of senior government employee to equalize his pay with that of his junior. On examination of such proposal, it has been observed that the administrative department refers such cases to the Finance Department in a routine manner without examining its merit or sometimes without the relevant papers. Equalization of pay of senior government employee or stepping up of pay of senior government employee with juniors is admissible on the following cases only. It is therefore impressed upon all administrative department to examine such proposal carefully and refer to Finance Department only those cases which fulfill the following points. Number 1, both the senior and junior government employee whose equalization stepping up of pay is proposed should be recruited to the same cadre post initially and should be promoted from the same source, which is not the case of the petitioner here. Number 2, when the disparity is attributed directly due to fixation of pay under FR 22(1) or under any other provision of FR and SR, no equalization of pay stepping up is admissible. So now that point 2 is also, my lord, not applicable in the present case. Then, my lord, will see point number 2, my lord, subparagraph 2, my lord, no equalization stepping up of pay is admissible in the following cases, and no such cases should be referred to Finance Department. We have made it clear. Number 1, when the pay of the junior is fixed with the benefit of advance increment sanctioned under special orders existing provision. That is not applicable here. When the junior gets pay protection for services rendered elsewhere prior to joining the present cadre post, that is also not applicable. Now this is applicable. Number 3, when a junior government servant promoted to a higher post prior to his senior as per special rules, special orders, he cannot claim equalization with his juniors who is in fact senior to him in the base post. Now in the base post, it is, my lord, the admitted position here that these persons, my lord, these 3 persons, my lord, namely Sri A.K. Deka, R. Singh and Samjidur Rahman, they were senior to the petitioner in the feeder cadre, my lord, feeder post. Now, now lordship will kindly, my lord, come to paragraph 7. Paragraph 8, my lord.
Paragraph
Paragraph 8
of the affidavit.
of the affidavit. That affidavit, same affidavit.
Yeah.
Because he is relying on FR 22C. Now, so what is the answer of Finance Department with regard to FR 22C? With regard to the statements made in so and so, answering deponent begs to state that FR 22C was deleted with effect from 1/1/1989, and FR 22C was related to fixation of pay on promotion. It is stated in the instant case is not about fixation of pay on promotion, but equalization of pay as claimed by the petitioner. So this is the, my lord, marked distinction between, my lord, equalization of pay, that is, my lord, stepping up of pay, or, my lord, fixation of pay on promotion. On promotion means, my lord, regular promotion. Here is a case, my lord, where the petitioner was not regularly promoted. He was abnormally promoted. Lordship may kindly come to my lord, page number 8. Page number 8 of that affidavit, my lord. The FY 22C has been, my lord, the 11% has been, my lord, annexed. Page number 8, my lord. Lordship will find in the middle, FY 22C.
Yes.
After comments, FY 22C, deleted by notification number so and so dated 8/8/1992, so and so with effect from 1/1/1989. Before its deletion, this rule was as under. So, my lord, the earlier existing rule has been relied upon by the petitioner. Even, my lord, under the earlier existing rule also, he is not entitled. Lordship will kindly see, my lord, FY 22C, I am reading it. Notwithstanding anything contained in these rules, where a government servant holding a post in a substantive temporary or officiating capacity is promoted or appointed in a substantive temporary or officiating capacity to another post carrying duties and responsibilities of greater importance than those attaching to the post held by him, his initial pay in the time scale of the higher post shall be fixed at the stage next above the pay notionally arrived at by increasing his pay in respect of the lower post by one increment at the stage at which such pay has accrued, provided that in all cases of promotion from class 1 post to under class, the pay for higher scale should be fixed, provided further that the provisions of FR sub-rule 2 of FR 31 shall not be applicable. So here Lordship will find it speaks of promotion. Now promotion
What is the meaning of this? 22C1.
22C1, my lord, if a person is regularly promoted,
Then
my lord, he will be, my lord, entitled. If a person is regularly promoted in the regular course, my lord, he is promoted under the service rules, then he will be entitled. But here is a case where the petitioner has not been able to show any material before this honorable court that he has been regularly promoted. He has been abnormally promoted.
so this is under 3F, 3D, 4D,
4D, my lord, or
4D. Isn't promoted under 4D under the PWD rules.
APSC regulation, but
APSC
APSC
regulation. Sorry, APSC regulation.
yes, officiating promotion for a period which is not likely to last more than 1 year. My lord, promotion, it shall not be necessary to consult the commission on principles to be followed on making promotions or on suitability of candidates for promotion in the following cases. Now, here it said officiating.
This is the 4D.
Yes.
Now you retired as what?
I retired as my lord. I retired as executive engineer.
Executive. You are
My 4D was regular, that order also given up.
you were promoted as assistant engineer.
Assistant engineer.
No,
Then assistant engineer, then assistant executive engineer, then executive engineer.
now 4D says, my lord, it is temporary promotion.
Correct.
It has been regularized.
So subsequently it has to be regularized because he is retired as executive engineer.
No, not that. Because, my lord, here, my lord, the
4D is temporary. You all know 4D is temporary.
temporary and
But
where
subject such approval will be granted later where he is regularized.
yes, now my lord, subject to approval, my lord, if it is approved, my lord, at a subsequent date, then it, my lord, because
Then
this
he-
time,
Then his appointment will be regularized, effect of the date.
with all respect, my lord, I beg to differ because of the reason, my lord, because, my lord, this is a transitory provision. This provision, my lord, this provision speaks of, my lord, only with regard to whether consultation with the commission is required or not. Because it is the parent department who is to take the call. He is an employee of, my lord, the parent department, not the commission. So therefore, if a person is, my lord, promoted for 1 year, my lord, less than 1 year, my lord, which is likely not to last for more than.
The issue is
Yes.
whether 20 prior to being deleted, the benefit available.
No.
According to you, if he is promoted temporarily, etc., he is not entitled. Now, it will have to be examined by the concerned department. What department is it?
Transport.
Transport, inland water transport.
Inland water
From
transport.
PWD, what happened?
No, PWD rule is applicable. PWD is the parent department. That rule is all applicable to so many other departments. So,
Your employer is PWD or?
no, inland water transport, matter.
Eh?
But the rule which is being followed, that PWD rule is followed.
Oh, PWD.
I'm not aware whether.
It should be aware now. You are arguing a case.
Where is your original appointment order? Is it here?
No, promotional order, your lordship asks for, my lord, that.
No, assistant engineer.
Assistant, yeah, my lord.
Sub-engineer.
Sub-engineer is not there, my lord.
Sub-engineer. Where is that chart?
Chart and the gradation list also I have enclosed, my lord.
Now, my lord.
If these are now controversies raised regarding that, my lord.
Whether, my lord, with all respect to my senior colleague, my lord, whether now an argument is being developed, my lord, that the PWD rules are applicable. That is not the pleaded case of the petition.
Not required, my lord. This
My
is,
lord, yes,
they're appearing from the department, they should know.
we are now, we are now taken by surprise.
Then produce the rules then. You have the rules. Produce it. I may be wrong still.
Your appointment order, etc., will be required. To
Well, my promotion order, lordship, can you see?
promotion, we have seen this is.
It has to be by the same promotion 4D, my lord.
But
Deputy Secretary to the government.
4D and to officiate as an assistant engineer in the inland water transport department.
Yes.
Now, whether in inland this PWD is applicable or not?
If the rule is applicable or not, my lord. My instruction is, that's why I produced it. If there's something is contrary to that, my lord.
What is this?
That is 4D, my lord.
No,
Lordship was
4D, there is
advised
no controversy on 4D. There is no controversy.
Yes, no controversy.
If he would have continued as 4D and then reverted, then no claim.
No.
But from the sequence of facts, it appears that 4D promotion was there, subsequently further promotion, and thereafter he superannuated as executive engineer. But unfortunately, all these orders are not here.
Normal, only issue was this, and lordship asked me to
Correct,
produce.
but now see you have relied on these PWD rules.
Only regard, no, my lord, that is not in controversy. That is not their case that I was promoted earlier. They have enclosed a chart. I am relying on that only. They have never said that I was not promoted earlier, my lord.
Mr. Chakraborty, controversy is with regard to whether 22C is applicable or not.
My lord.
Now, for that, some reference has to be made to the service rules as to how you were promoted.
Yes.
How I am promoted is given, my lord.
Where?
Is that 4D and then confirmation. 4D is by the department, and lordship kindly see the next page. 4D has been regularized.
The fact that why were you promoted ahead of your senior?
Yes.
You are
that's the
referring
question,
to
yes.
these rules under the PWD.
Yes.
Now, whether these rules are actually applicable or not, or at the
Only
relevant.
that instruction required, they may get it, my lord.
No, my lord,
Whether the department is following this PWD rule, I have a clear instruction, my lord. PWD rule is not followed in this. My lord, many other department PWD rule is followed.
Yes. Now, my lord,
Because it's not
yes.
those who are having engineering services, all in the state of Assam, they follow the PWD rule, my lord.
No, there are different works department, they have their own rules. There are different work department, water resources, and what is the other department?
That instruction over,
Public health.
one of these instructions they can have over telephone also, my lord.
Education department is there, my lord.
Over telephone also, if it is not correct, then
Now, my lord, with all respect, even if we admit the argument.
See.
Yes.
The controversy is not whether he was promoted or not. Your document has held, the affidavits of the respondents have categorically held that there is a chart that he was promoted earlier.
Yeah.
There's no dispute on that. The only question is in terms of Rule 22C, whether this promotion was by way of special or extraordinary circumstances.
That was.
Now,
I am about to submit.
this 4D
Yes.
subsequently was regularized.
Yes.
He was promoted on 8th of April, 1981.
My initial 4D has been regularized, madam. That order has been regularized.
It has been regularized from which date? From 19 January 1984. Regularized from which date?
It says that my why the financial transfer is hereby regularized. So 8181, my lord. 88. It should be 8481, my lord. Typography. Original I have given, my lord.
No,
Typography.
not like that. 8480, 8181.
84. It should be 84, my lord. Original I have given, my lord. It is very old document. That's why typographical mistake is here. 84. The first order was 84, my lord. I have the original, my lord, but very much illegible. That's why.
The order is that you are hereby regularized.
My lord.
With effect from which date? That date is not here.
I'm going to the
So it will have to be presumed that you are regularized with effect from 19 January 1984.
Lordship, the charts, kindly see, my lord, at page 43, my lord. It says I was promoted as executive engineer on 7/4/81, my lord.
7/4. Now 7/4.
This is 8/4, but 7/4.
But your order says it is 8/4.
8/4, my lord.
The order itself is 8/4. Anyway,
One day, my lord, that
the chart is okay, but your regularization.
and my gradation list, lordship, kindly see, my lord, that I have
No,
included in the petition.
you have furnished a notification regularizing your services.
My lord, page 16 of the petition may be seen, my lord.
It says you are regularized on 1984.
Page 16, lordship, kindly see, my lord.
Yes.
'69 sub-engineer, 8481 here correctly written, my lord, as assistant engineer. 6886 assistant executive engineer, and thereafter this was old gradation list. So these are not in controversy, my lord. And their own chart, their comparative chart they've given, my lord. Now, whether PWD rule is applicable to the department or not, my lord, for that telephonic instruction we will do, my lord. That will
Rules
produce.
since which date?
Right.
Since which date? When, what are your rules called? What are your rules? You say, what are your rules?
If Lordship, he is relying on the PWD rule. Here is a case, my lord, where he has superseded his seniors. If he can able to show, my lord, within that rules, my lord, which is placed before your lordship, that the rules provide for superseding the seniors.
No, it's not superseding.
Yes.
Rules are clear that this is with Rule 11. Rule 11
My lord.
is with regard to promotion to assistant engineer.
My lord.
Now, your promotion to assistant engineer is subject to following conditions: 8 years of service, undergone training, passed departmental examination, and acquiring academic qualifications as prescribed. on acquiring academic qualification as prescribed for a direct recruit, he shall be promoted as assistant engineer in consultation with the commission against the next available vacancy and be treated to be a direct recruit. Now, the direct recruit qualification are provided in this schedule.
But that is also their qualification. Last page you also will get, madam. Page 19, schedule 2.
Must possess a degree in the respective branch of
Or must have passed part A and B. This one I passed, madam.
or
Or
must
the
have
associate
passed
member
part
examination.
A and B.
Yeah, ma'am. This one I
Associate.
cleared, madam. Even if my date is 84, my lord, then this
But-
22 has been deleted in 89.
So that's okay.
But even on, what I'm saying, my lord, they were the other day, there is a.
Mr. Chakraborty, this rule 4C, 4D, 4ABC.
My lord.
Now that is 11-4C. You are to be, if you acquire academic qualification as prescribed for a direct recruit,
Which one, my lord?
this
Which,
PWD,
my lord?
you have a copy?
My lord, sorry.
So if you are
Rule?
rule 11-4C,
Yes, post, yeah.
this is the rule you are relying on.
Yes, madam.
So as per this rule, you will have to be treated to be a direct recruit.
My lord.
If you have the qualification
Oh.
for direct recruit,
My lord.
you shall be promoted as an assistant engineer
My lord.
in consultation and so, and such promotion shall be treated as direct recruitment.
My lord. Otherwise, my lord, there would have been litigation definitely, my lord. I in fact superseded so many junior, my lord, senior. That was not there. This is only because of this reason, my lord. The rule was very clear.
Anyway, you give us the name of the rule, what was there.
And from when it was applicable, my
It
lord.
is possible that,
Record no, rule only.
no, it is possible that at the relevant point in time, you had relied on the PWD. Possible.
Objection all, but he has still his order is not under attention. So ultimately,
Which order?
in my application, I have done it with 45 practically.
No, but it is, if it is his pay and which is required to be, he is entitled to.
But he pays 45 with income immediately to the bank. After 4 years, he has he never challenged his order. 8, 12, 15, that one. I am ready to inform. As your pay was informed more than the other instance, that we take a card period. Hence, there is no scope for other text.
Very well. You get the,
Also, my lord, also she should read 34, my lord.
Huh?
34 she should read, my lord.
34.
Page 34 of the petition, my lord. Can you see? I made an RTI application, say that your matter is under consideration of the government. Can you see, my lord? With reference to your letter, I am directed to say that the prayer for review of the decision communicated by letter number so and so, and for 811, my lord, you kindly see that was under review. And for fixation of pay, stepping off of the pay to the relevant period, and pass necessary order for fixation of pension on the basis of fixation of pay, and counting his period or the non-gazetted pay is under active consideration of the government. This is under review and it was under active consideration of the government. This was pursuant to the order passed by this honorable court earlier occasion, my lord. They are sitting over the matter, then had come, my lord.
Very well, you come again, come again. You give us a photocopy, you retain this.
I have a photocopy, my lord. Your
You
lordship
give
can-
it to us. You can keep this. Call up the matter next week. We call up next week. Mr. D. Chakraborty, for the petitioner, Mr. R. for Pujari for finance, and Ms. M. P. Bora for transport. Learned counsel for the transport, will give the report, the relevant service rules governing the services of the writ petitioner and the transport department. By the next,
which was applicable at the time of its promotion, my lord.
which was applicable at the time when the petitioner was promoted in
Yes, yes,
1980
Yes, Engineer.
1981.
81.
That's 40 of.
That will be called up next week.
Okay, madam.
We called up on Thursday is a holiday.
Next Tuesday, my lord.
Next Tuesday.
This is
Follow
part
up on-
third, my lord. This was the last occasion.
Of course, it is part of
Right.
it. Next Tuesday. All right, you mentioned it, will post it. Let it be called up. Yeah. Yeah.
I'm obliged, madam.
Itu writing to photo. Itu original to writing photo.
Lord, with further instruction, my lord.
Yes.
Lord, she is receiving her pension regularly, my lord. And no deduction has been made till date, my lord. There were 3 deductions earlier, my lord. It was not related to this, my lord. It was not related to excess payment. So it was some other matter. She is regularly receiving her pension.
Even now.
Yes. That is receiving her pension and no deduction has been made.
Made Pidgin Lodge. So the engaged counsel is on the way. He's coming here in court 7.
What pension is she receiving? Special family.
It's receiving special payment.
Huh?
The
Then what further orders are necessary?
Lord, case, my lord, it's my lord.
The respondents have submitted that your petitioner is continuing to receive her pension.
He's continuing entire thing.
Entire pension.
That is not deducted. Recovery is not.
No deduction has been made till date.
That's its submission. Do you have any document? You're for the SBI. Who was supposed to make the deduction?
SB.
No deduction has been made till date.
What is the amount? That is
Last. Pension.
I'll just go through and then check. Lordship may take it up some other day. Immediately next week.
Matter 7 and 8 be called up next week as it is submitted by the respondent council that there is no deduction made to the special what pension? Special
Family pension.
family pension granted to the writ petitioner. Learned counsel to the petitioner seeks some time to verify. The statement made by the respondent counsel, complete is instructed. Let the let matters be called up next week. Yes.
In this case, they have being for the ad hoc pension of rupees 400, otherwise we are hard the matter. Our stand is that from 2010, it was discontinued. No one getting their pension. Because that was revised and enhanced payment pension was paid to all the employees of our. Or
Let
in
the
affidavit-
petitioner come.
Yes.
None appears for the writ petitioner. Mr. K. Kolita appears for the respondent, Oil India.
Yes.
Matter be called up again next week.
Alright.
For that, why do you have to make a mention? We are only asking you who will be available. At 2, this bench is not available.
Lordship, I had one request. Lordship, in item number 48, we have received the videographs that they have started demolition of the said buildings using JCB and proclaim. So if the council appearing for the police officials may be directed to just inform them to stop
You serve the copy of the order. It will be available in a short while from
in
now.
a short while.
Yeah.
Much obliged.